Hello, my name is Osha. I like to talk about history, and I'm going to be continuing my discussion in honor of Stress Awareness Month. This is the month of April 2026, and it's also Autism Awareness Month. Of course, autism is a form of mental illness. So I'm looking at mental health laws. I did a video discussing um, uh, Elizabeth Packard, who in the 19th century, following her wrongful involuntary commitment in an insane asylum by her husband, religious fanatic husband, a Calvinist, Theophilus Packard. She was able to win her freedom and she became a prominent advocate and author, um, you know, uh, with respect to mental health laws. Now, uh, we're going to be moving forward, and today I'm going to be discussing Donaldson, the case of O'Connor versus Donaldson, right? So Kenneth Donaldson was the patient, and he was uh, involuntarily committed for 15 years in Florida State Hospital. And his case went all the way to the Supreme Court. It's a landmark case, and he sued and he won. So it established a law stating that even a person who's mentally ill, right? But so long as they're not dangerous or they're not receiving treatment, so long as they're not dangerous, they cannot be committed against their will. They cannot be involuntarily committed against their will. If a person is who's not dangerous, even if they're mentally ill, and that of course established the standard. That's a national standard. So, for instance, in a state like Maryland, uh, before they can commit someone, they have to show that they're mentally ill and that they're dangerous. Those two elements have to be satisfied, right? Although in the state of Maryland or Montgomery County, they use other mechanisms, other means, illegal means, so they commit fraud. They have cops who commit fraud. Unfortunately, they give their cops who have maybe just a GED. They're not rocket science. They allow them to make these determinations, which is unlawful. Of course, these are things that we can appeal, take it to state legislature to make sure, to the state legislature to make sure these powers are taken away from cops who are uneducated, undereducated. They're not qualified to make decisions that psychiatrists are supposed to be making. And of course, we know even psychiatrists as well and providers like Suburban Hospital, MedStar Hospital, they tend to commit fraud as well. And so they will they circumvent the process. Even judges who are meant to protect you, judges like Montgomery County's Judge James Bonifant, he's retired now, but he's still a senior judge. So something has to be done. Of course, there can be a petition to make sure that he's prosecuted by the federal government for his long history of fraud and violating the constitutional rights of citizens with respect to his health, his collusion in healthcare fraud, mental health care fraud, and wrongful confinements of Americans. Uh, now, so Kenneth Donaldson was a patient, but he changed the law. He went all the way to the Supreme Court. And now let me just clarify, because how is it that mental health actually is within the state's purview, right? It's within a state's police power. It's within a state's purview under the Constitution. Um, well, it's not expressly stated in the Constitution, but we find that Kenneth Donaldson's case went all the way to the Supreme Court, and the Supreme Court made a decision saying, well, if a person, if even if the person is mentally ill, right, so long as they're not dangerous, right, they cannot be involuntarily confined. They can't be confined against their will, so long as they're not dangerous or they're not receiving treatment. So long as they're not dangerous, they can be confined against their will. So how is it? Is it a state matter or a federal matter? So I've done videos talking about the various amendments. So this is a 10th Amendment matter. So remember, the 10th Amendment delineates between state and federal powers. So the 10th Amendment says that uh, powers powers not delegated to the United States government by the Constitution, right, and not prohibited to the states, right, are they're reserved to the states or the people. So this is one of those, right? Uh, it's not delegated. It's not expressly stated in the Constitution that mental health or public health, that it's within the United States federal government's purview, right? It's not stated in the Constitution that it's within their powers. At the same time, it's not prohibited, uh, in the Constitution. It's not prohibited to the states, right? So it's one of those powers that fit in nicely within the 10th Amendment. And so it's reserved to the states. And so that's when I say the powers, that's the police powers. These are considered police powers. So it allows states to regulate public safety, health, and general welfare, public welfare, because again, so that's within the 10th Amendment, because it's not delegated to the federal government by the Constitution, and it's not prohibited to the states, right? So that's the state police power. But since it's under the state police power, right? It's under their state police power to regulate. Then why was Donaldson able to take it to the Supreme Court, and the Supreme Court made laws regarding that? Because it implicates liberty, right? So liberty interests, our fundamental rights, our liberty. That's within the Constitution, right? That's within the 14th Amendment. So it still implicates the 14th Amendment. We have due process of law, equal protection of the law. So it implicates the due process. And even so, that's a reason why the federal government, the Supreme Court, was able to make laws sort of restricting what states could do with their police power over public health and safety, over public health and safety and welfare. Because again, mental health is within the public health sphere. Now, but still, the federal still exerts authority over the states regarding uh, health, health matters, public health, in that it's the through funding, right? It's the federal government that provides Medicaid, Medicare, and block grants to the states. Although the states, they design their own respective um, policies and laws on how to administer these programs. So, but the federal government still provides guidelines uh, to make sure that the fundamental rights, liberty of U.S. citizens are not violated. It's still a constitutional right. That's federal matter. It's constitutional right when things affect our fundamental rights, our freedom. We have a right to be free uh, from confinement, right? Due process. We have a right to be free from confinement. That's within our liberty interest, our fundamental rights. And so the federal government is still implicated, and the federal government so therefore sets federal guidelines, including HIPAA laws. I've talked about HIPAA laws and anti-discrimination laws. That's ADA, Americans with Disability Act. So those are things that are drafted, designed by the federal government to still regulate the states, even though the states um, have police power, they have authority over health, public safety, and the welfare, right, of its citizens. So, and that's how this matter made it all the way to the Supreme Court. And but let me give a uh, quick background information on Donaldson. So Donaldson had actually been institutionalized by his family. He'd had a traumatic episode, and so he'd received treatment for mental health, and he'd been released. But so he did have a history of mental illness. So this wasn't a matter of determination of whether he had mental illness or not. He did have a mental illness, but what the state was just basically saying was, even though he had a mental illness, he still had a right to be free, right? The courts eventually said, you just can't fence off. That said, you can't just fence in people who have a mental illness because maybe the to prevent them from being exposed to the public, right? So long as they are not dangerous and they're not receiving treatment, they still have a right to refuse treatment. So long as they're not dangerous, they have a right to want to be to not to be institutionalized. They have a right to live alone, or if they can't live alone, so long as if they have family or friends who are willing to take care of them, to support them, they have a right not to be institutionalized, not to be fenced in, as the court put it. So so and the court used an analogy that if that were the case, then soon it would although that's like a slippery slope fallacy, and the court does that sometimes. That if you could just confine people because they have a mental illness, but they're not dangerous, and because you don't want them to be exposed to the rest of society, maybe because they're eccentric or whatever, then uh, it would justify instances where people, just because they're not attractive, right, then the state can go and confine them, can lock them up just because they're not attractive, or because they're eccentric. The states would soon be, they would soon be, treading on those dangerous grounds. And so, the Supreme Court said no, that the fact that someone has a mental illness, so long as they're not dangerous, they're not receiving treatment, they can't be confined against their will, right? They can't be confined against their will. Uh, and it was also important that the federal government also stated that that even if the state is saying that they're able to provide them a certain standard of care, welfare that they can't provide themselves because of their mental illness, uh, the courts, emphasize that it's still up to the individual. The individual, even if they can't really provide themselves, people would rather like to be alone, to live on their own, right, have their freedom in their own home, right, rather than being institutionalized, being put in an institution, right? Their freedom is still restricted. People don't like that. The fact that, well, you can give them 3 square meals of, a day. People still like to be alone in their home. I like to enjoy the freedom of being unrestricted within their own home or amongst their friends. So that's the significant outcome of the landmark case of O'Connor versus Donaldson. O'Connor was the psychiatric superintendent at the Florida State Hospital. And, as I said, Donaldson had a history of mental illness, but sometime later, maybe, at some point he traveled to Florida to visit his parents, and then he expressed his, some kind of paranoid delusions. Like he said, he believed his neighbors were poisoning him, and so his father went to the court, had a sanity hearing. Remember I talked about um, how the case of Packard, would establish equal public hearing if before they can confine someone. They're entitled to a public hearing, right? And so the father had a sanity hearing, right? They had a hearing, and they did an evaluation, and he was diagnosed with paranoid schizophrenia, right? So because he was diagnosed with paranoid schizophrenia, he was committed. But while he was committed for 15 years cumulative. But throughout, he refused. He wanted to be released. He stated that he refused to accept that he had a mental illness. That was one. And that's a funny thing. I guess when you're telling some of these institutions, facilities that you don't have a mental illness, and they've already, one doctor said you have a mental illness, then they'll say, well, you must be clearly very severely delusional, right? So, but he refused treatment. So throughout those 15 years, he never accepted treatment, and he was never dangerous, right? And unfortunately for him, they put him amongst dangerous people, dangerous criminals, very dangerous criminals, but he was never violent, and he refused treatment. He never accepted treatment, and he insisted that he didn't have a mental illness, and he insisted he wanted to go, he wanted to leave. And there were friends who were also petitioning on his behalf to leave. So eventually he filed a lawsuit against the institution, and he won. He even won damages as well. Um, of course, with the issue of damages, it went back and forth, and of course, it went all the way to the Supreme Court, and we have uh, that rule that even the mentally ill, so long as they're not dangerous, they cannot be confined against their will, right? So long as they're not dangerous. So that's a standard for confining somebody in a mental institution. They have to, first of all, be mentally ill. And not just that, but they've got to be dangerous, either to themselves or to the public. They've got to be dangerous. And then the other thing is, they're receiving treatment, right? He was not dangerous. And so the Supreme Court said they couldn't confine him, and he was released. He With regard to the damages, they went back and forth on that. There was a court who awarded him damages. 15 years is a very long time. He became very well known. He wrote a book on it. He became well known, and so he gave us that landmark decision that you can't confine uh, people so long as they're not dangerous. So, and that's the case. Now I'm going to get into other case. There's another interesting case, Addington versus Texas, which set the standard, right? Before they want to determine if somebody has a mental illness, there's a standard, right? Of course, if somebody's in a criminal case, the legal standard for convicting is proof beyond a reasonable doubt. So there are these legal standards, right? In civil cases, the if you have a civil suit, right, and you're in a dispute with the party, if it's civil suit, uh, uh, you know, the prevailing party, their standard to win is preponderance of the evidence. Preponderance of the evidence. Say 51% versus 49%. Now, there's a case that established the standard, right, for commitment, that somebody has a mental illness, the standard for commitment, that that person has a mental illness with through clear and convincing evidence. Sometimes they call it clear, unequivocal, and convincing evidence. So that's the standard. I'm going to do another video and discuss the case that established that clear and convincing standard for confinement for a mental illness. So, another reason, of course, why I got into discussing uh, mental illness and the cases that deal with mental illness is because of the now very popular call for invoking the 25th Amendment against the President of the United States, number 45 and 47, uh, since his expletive-laden, vitriolic posts against Iranians and his threat to commit genocide or annihilation of the Iranian people, the Iranian civilization. Of course, it mortified Americans, and even former Republicans who formerly supported him, people like Candace Owens, talking heads like Candace Owens, um, former Congresswoman Marjorie Taylor Greene, Alex Jones, talking heads, they're all calling for invoking, the 25th Amendment against President Donald Trump. So the 25th Amendment, it provides for a president who lacks capacity, right? For a vote of the majority vote of the vice president and the cabinet members or another body provided through law by the Congress, right? They have to have a majority vote, and he can be removed for lack of capacity, for being unable to fulfill the powers and the duties of his office. But again, it's in Section 4, and it looks like it's a temporary it's a temporary mechanism, and the president can always counter with by providing an affidavit that his inability to his inability to fulfill the powers and duties of the office has been removed, right? If he can counter, it can go back and forth, and then ultimately Congress has to vote by two-thirds majority, two-thirds of both houses, right? They have to make a decision if the vice president will continue to serve as the acting president. Um, it's very difficult. How do you make a determination of incapacity of the president, right? So that's why I'm going through these cases. It's very difficult to make such a decision, short of the president actually wearing no clothes and coming in public, right? He'd have to literally wear no clothes and come in public, or he would have to get out a gun and try and kill somebody in public, do something in that case, and that would be a serious crime, or he'll be committed if they say, well, it's because of this mental illness that he has. So short of being actually committed, but he's a very wealthy man. He will always be able to get, a psychiatrist on his side to dispute, to contend, and you have to first of all get him to have an evaluation. And there's standards that are required, right? So for saying somebody uh, is mentally, severely mentally ill, right? It's not simply because they make bad judgments, right? People make bad decisions. No, it's not because they make unpopular statements. No, a mental illness, that person would have to be going through psychosis, for instance, hallucinations, right? Things like that that are clearly impairing. And mental illness can be very subjective. So short of that, it's very difficult, almost impossible. Although that section is there, Section 4 of the 25th Amendment, but it's never been invoked before, right? It just came into being in 1967, but it's never been invoked, and so that's a reason why I've been going into these cases dealing with mental health. My name is Olurotimi Osha, and I will continue with subsequent videos discussing cases that have defined mental health laws in America and for protecting the rights of American citizens. My name is Olurotimi Osha. I'll keep you posted. Thank you.